Hello, RobbbRyder here. The following is freely shared with all peaceful people. While you may not fully understand what's being said, it's only due to lack of knowledge on the lawful way of ending your suffering. You also need to accept that you are the problem. You need to get your mind right, quit arguing with them, suing them, charging your brother. Stop it now. It's much easier to give them a lawful order. If you can go in peace, forgive, ask forgiveness, and leave the baggage behind, then this is the start of the journey out of Egypt. I'm unable to explain why is what it is as part of this video. For that, go to Rob, R-O-B, Court of Record, COURTOFRECORD.wordpress.com. I have many audios I've done and writings that have led me to this. This is just the tip of much research in the past. This video is geared to just one of the areas where a lack of knowledge is causing your suffering and what you can do about it. This lawful process will give you ownership of your real estate. You will no longer be a tenant and can be completed in as little as a half an hour. This same lawful process will be used to secure your ownership of your real property and interest, known as your all-capital letter name. It's the name of a landed estate, and we'll get to that in the future. But for now, let's talk about one thing that we can do something about today. Everyone who has a mortgage or deed of trust knows what it is. In real estate in the United States, a deed, a trust deed or deed of trust, is a deed wherein legal title and real property is transferred to a trustee, which holds it as security for a loan between the borrower and the lender. The borrower, you, is referred to as the trustor, while the lender is referred to as the beneficiary of the trust deed. Transactions involving trust deeds are normally structured so the lender gives the borrower, trustor, you, the money to buy the property, comma. The seller, the guy who has the property you want to buy, executes a grant deed, giving the property to the trustor, you. So what this is saying is that there is a grant deed, commonly known as a warranty deed, that is between the seller, on which this deed, he'll be known as the grantor, to the buyer, which is you, and you'll be known as the grantee. It doesn't have anybody else on it. There is no trustee. It's just a grantor and a grantee. It's a common law deed, and it's the very first piece of paper produced when you're doing property. So let's take a look at one. Okay, here's a warranty deed, State of Georgia. 29th of August, 2003, between some group, hereinafter the grantor, and some person, hereinafter the grantee. The grantor, for said consideration of $10 and other good and valuable consideration, in hand, paid at time before the sealing and delivery of these presents, the receipt whereof is hereby acknowledged, has granted, bargained, sold, a lien conveyed and confirmed, and by these presents does grant, bargain, sell, a lien, convey, and confirm unto said grantee. So this says for $10, the grantor gave the grantee this property. And there it is. This deed is also given subject to all easements and restrictions of record, if any. To have and to hold the said tract parcel of land with all and singular rights, members and appurtenances, sorry, I can't say that word, thereof, to the same being belonging or in any way appertaining to the only proper use, benefit, and behoof of the said grantee forever in fee simple. Fee simple is ownership. You're not a tenant. You are now the owner. You have ownership rights. You have the right to use right to enjoy, right to dispose of. You can never sell this house for more than $10. All that is fiction. We don't own the houses. They're owned by the Creator. They're His. He gave each of us an inheritance in land and tenements. Your land is your body. That's why you're the law of the land. And we'll find out how powerful it is shortly. But that's all He gave you. Everything else is public property. However, as a man, if there's an empty house or the one that you're in now, you can have ownership rights in it because you're a man. And this is how we're going to do it. So what you looked at was a warranty deed. A warranty deed is a type of deed where the grantor guarantees that he or she holds clear title to the piece of real estate and has the right to sell it to the grantee, to you. The guarantee is not limited to the time the grantor owned the property. It extends back to the property's origins. So he's telling you that it's warranted back to the date of the original land patent. So you don't need to get a land patent. You just need to deal with the warranty deed. Now, let's look at this again. So on here, on the right-hand side, is the signature for the grantor. And then in the middle is a witness, and it was a notary. So this has the grantor on it and the notary. And that's how this was originally recorded. Okay. Well, because this notary doesn't have there's not another certificate saying that this notary is authorized to do this. Basically, it's called a certificate of authority. And it's just a short piece of paper that says, yeah, the notary's on file and can do this. And we'll look at one in just a second, what one looks like when you do it right. But this is how this was originally recorded into the Register of Deeds. So let's say what Bouvier has to say about to record. Sometimes questions arise as to when the act of recording is complete, as in the following case. A deed of real estate was acknowledged before the Register of Deeds and handed to him to be recorded. And at the same instant, a creditor of the grantor attached to the real estate. In this case, it was held the act of recording was incomplete without a certificate of acknowledgement, and wanting that, the attaching creditor had the preference. Now, before we go any further, the fact of an instrument being recorded is held to operate as constructive notice upon all subsequent later purchases of the real estate, legal or equitable, in the same property. So a properly recorded deed lets anybody else know ahead of time, hey, I'm the owner, you need to come talk to me. Your grant deed is first in line, first in time, goes back to the date of creation. And is good title. They only have marketable title, meaning it has a defect. The defect is the owner might someday come in and have acknowledged the certificate completed on his grant deed. And when you do, their title is worthless. You are no longer a tenant. You're the owner. So right now, with it the way it was, we'll look at it again in a second, but right now, but all conveyances and deeds which have been de facto, not lawful, recorded, are not to be considered as giving notice. In order to have this effect, the instrument must be such as are authorized to be recorded, and the registry must have been made in compliance with the law. Otherwise, the registry is to be treated as a mere nullity and will have no effect on subsequent purchases or encumbrance unless he has such actual notice as it would amount to a fraud. So, let's go back and look at this. Okay. So here we have a deed that the grantor has acknowledged. However, in common law, for a deed to be binding, both the grantor and the grantee have to agree. Well, I don't see anything on here that says anything about you. You didn't sign it. So what do? Well, if you want to acknowledge this deed and have it in fee simple as the owner, you need to acknowledge the deed. And I'm going to show you how easy that is. Just a second here. Let me pop this down. A certificate of acknowledgement. I, Linda Marie, the living woman in capacity of Linda Marie Bailey, am recorded as a grantee in the warranty grant deed of the real estate, described and attached certified copy of said deed. It is my free will act and deed to acknowledge my acceptance of the deed and lawful ownership of the property under the terms of the deed. I ask the record on file in the Office of the Register of Deeds to be updated to show my acceptance of the deed and the lawful owner of the real estate. This is my free will act and deed under my hand and seal. And Linda did it, and she decided to have another witness, which is fine with me. Then your version of this at the bottom, this is called a Acknowledgement Certificate. And this one's for the state of Georgia, county of. On this, whatever day, before me, the subscriber, who the subscriber is going to be the notary, personally appeared Linda Marie Bailey, to me known to be a living woman described in and who executed the foregoing instrument and acknowledged before me that she executed the same as her free will act and deed. And the notary put her seal on it. That was easy. Any notary public can do this for you. All they're doing is acknowledging that you've come in and said you've done this of your free will act and deed. You were not coerced into this. And so this is a memorial to your free will act and deed. So this is the certificate of acknowledgement. And it's under the seal of a notary, who is a judicial magistrate. They're a justice of the peace. And their seal can't be challenged by any court anywhere. However, we got to make sure that this notary is in the book as being a notary. Could be a forgery, could be a fraud. So how do we do that? Well, that's pretty simple too. In Michigan, you go to the county building, and in Georgia, it looks like it was the same, because this certificate is what they gave Linda, state of Georgia, county of Walton. I, Melissa J. Malcolm, Deputy Clerk of the Superior Court, Walton County, Georgia, the same being a court of record of the foresaid county, having by law a seal, do hereby certify that Margaret Young, whose name is described in the foregoing affidavit, was at the time of taking said affidavit a notary public, duly commissioned and sworn, residing in said county, and was, as such, an officer of the said state, duly authorized by law, therefore, to take and certify the same, as well as to take and certify the proof and acknowledgement of deeds and other instruments in writing to be recorded in said state, and that full faith and credit are and ought to be given to her official acts. I further certify that I'm well acquainted with her handwriting and verily believe the signature in the foregoing affidavit is genuine signature. In witness whereof I hereunto set my hand and fix my seal. Now look at the seal you get. This is from the Superior Court, which is a court of record. And in law, under seal of a court of record is binding on all other courts around the world, period. The Supreme Court can't turn it over. So what you have done, without getting too deep into this subject, because this could take hours and hours and hours to explain to you, you're the tribunal of the court of record of final jurisdiction of your sovereign nation state, of your land. Linda Marie Bailey is the tribunal of the court of record. And in a court of record, when you go to see a judicial magistrate, they're there merely to administer the orders of the tribunal. Well, here's Linda's order. The magistrate administered it, and one of their courts of record says it's due full faith and credit per the Constitution. So for anyone to go against this order, free will, act, and deed, whatever you want to call it, they would have to war with the Constitution. And that's treason. And that's a powerful tool. So this is how you end your nightmare. Do an acknowledgement similar to the one below. I've changed it slightly from the one that Linda did. That was my first swag at it, and I thought about it a little more, so I'm going to show you a different one. Linda, it's no big deal if you hear this. You know, yours will be fine, but I just thought we should add something to it. Do an acknowledgement similar to the one below. Find a competent officer and have him, speak these words. I wish to have this instrument of my free will act and deed acknowledged. You can use a notary public, a justice of the peace, etc. Many officers are considered competent officers. Just ask for one. If you're in the courthouse, they're there. They may not call them a notary public. They may have another name, but they're called a competent officer. You just say, I need a competent officer to seal my acknowledgement. Find me one. Find out where you get a certificate of authority for the officer that just sealed your instrument. Here in Michigan, it's the county clerk. Some states may require you to go to the Secretary of State. At the end of the day, you want a certificate of authority, not an apostille. I don't know that they call it a certificate of authority, but what you want is you need to have the notaries or competent officers commissioned certified. This certificate of authority says that the officer that just witnessed your instrument under his seal has a commission to do so. So please don't ask me where to get the certificate from. Ask them. Don't be emailing me looking for an answer. Go find it. That's your job. If they balk and act dumb, act like a counter troll. Simply say, I accept your oath. Are you acknowledging that you are denying me due process? Do you know that is treason? If you're not, then go find out where I get this officer's commission certified. Now, if you are, then bring me your boss immediately on a bailiff because you're committing treason. So when you're successful, and you will be, take both the acknowledgement and certificate and head to the office where the real estate is recorded. Ask for a certified copy of the warranty deed. Remember, it only has two parties, the grantor and the grantee, the guy that sold it to you and you. If they act stupid, then ask to see the whole record, and you'll show them what you need. Again, just you as the grantee. And it has a grantor. You do not want the deed of trust or the mortgage deed. When you are successful, and you will be, hand the clerk your acknowledgement, the certificate of authority, and the copy of the deed she just gave you, and tell her you want to record your acknowledgement of the deed, and get a few certified copies for your records. Congratulations. You are now the owner of your real estate, lawfully, and no longer the tenant. When they comply, and they will, you will now have good title to your property, first in line, first in time. So the marketable title being used now will be rendered null and void, as is anything attached as debt. You have good title, fee simple. When they record your instrument, the deed that was in the other file, where you got the certified copy out of when you walked in, it only has a marketable title. It doesn't have the other seals on it that yours now does. You have a record, a public record. This is a private record, what they have. So it's de facto. It's only de facto, not properly recorded. A marketable title has a defect and is inferior to good title, which is why you need title insurance for a marketable title. Now that you've made it a lawful deed, also known as good title, and it's recorded in the Doomsday Book, which is in the Register of Deeds office. That's the book they put it in. It's one of its many names. Their marketable title no longer has any value. Anything attached to it in that old record is not your problem. That's why they have insurance. You own the property based on the original deed at its initial recording. Fee simple. So this is how I would change, what I call my acknowledgement. I don't own any land or property, so this isn't doing me a bit of good, but I can see that it can do a lot of people good. So you would have to change it to you, and obviously you can see the parts you'd have to change. I, Robert Allen, the living man, created in the image of God, with indefeasible title to my land, and lawful owner of the landed estate known as Robert Allen Rutluski, and it's real property and interest under the seal, Robert Allen Merlewski, the way I would sign my name. I say that's my seal. They say it's a signature. I'm the law. They're the servants. I just told them what it was, and when you have this done, it will be the law. And recorded as the grantee on the warranty, grant deed, for the real estate described on the attached certified copy of said deed. It is my free will acted deed to execute this acknowledgement of my acceptance of the deed and lawful ownership of the property under the terms of the deed. I ask that the record on file in the office of the Register of Deeds be updated now to show my acceptance of the deed as lawful owner of the real estate. All of my other real property and interest attached to this real estate is to be immediately returned to me, done under my hand and seal of my own free will act and deed. And then this is the one for the state of Michigan. The important thing about doing these, you want to use some words that have substantive meaning, such as executed the same as his free will act and deed. Everyone gets hung up in the word executor, and if they go to the next word down, where it's executory, executor with a Y, which says it's an instrument in waiting to be executed, you've just done it. You have just executed the deed to accept the deed. You've acknowledged it lawfully, and now it's under seal. And so when Linda gets a certified copy of this out, you'll notice this red sticker on the side. This isn't a certified copy like you normally get out. This is under the seal of the Court of Record. The Clerk Supervisor Court, Clerk Superior Court, Walton County. It's not the same as just getting a certified copy of a record that they normally have in there. And as you can see here, it was recorded under deed, not under miscellaneous or some other bullshit. No, it was put in under deed. And so now think about this. The deed that they handed you didn't go back to the same place it came out of. It went into another spot in a record book. And at the end of the day, title examiners come in and check all the books to see what's been put in the books. And when they see that, they're going to say, well, if this property is over here, what's in this file over here? The old file. It doesn't have a deed anymore. It's the only lawful piece of paperwork in there. Therefore, everything else in there is null and void at the moment. And so if anybody says anything to you after this, and I don't know that they will, but if they did, say, well, I have a public record that says I'm an owner. Where's yours? They don't have one. And in Blackstone's, he talks about the 7 types of civil courts. The very first one being trial by record. And the only defense in trial by record is to say that record doesn't exist. Well, sure it does. It's right here. It's recorded here. You have the record of where it's recorded. It's a public record. It's due form of law, guaranteed, full faith and credit, considered full proof, self-authenticating in any court case that you have. So if you're going through a foreclosure, go have this done, get a certified copy, go have it put in your court file. See what they do with that. And we'll find out soon enough, because that's where Linda was at. And as far as I know, Linda's the first one to do this. And high fives to her. She's leading the way out. Hopefully more are doing it today, but we'll find out. And once this is proven and evidence for those who need proof and evidence, then you will see how similar this process is that you just did for real estate will be for your real property and interest estate known as your all capital letter name. We're going to go accept that deed also and have access to everything that's in your account. We're going to have to leave that for another story. That's all I have for today. See you later.
Hello, RobbbRyder again. We're going to talk about why it's so important to have these seals and try to create a public record. And again, if you're looking for things I've done in the past, There's the WordPress site at the top. Right now we're going to concentrate on Book 3, Chapter 22 of the Special Species of Trials from Blackstone's Commentaries in English Law. And there is a link to an e-book. But if you go to someplace like openlibrary.org or similar and put in the word Blackstone, you'll find all sorts of different books you can look at, edited versions. This happens to be an online one, and there it is. So I'm not going to read everything in this chapter, just picking out the things that mean something to me. So, the uncertainty of legal proceedings is a notion so generally adopted and has so long been the standing theme of wit and good humor that he who should attempt to refute it would be looked upon as a man who is either incapable of a discernment of himself or else meant to impose upon others. So either you don't understand what's going on or you're one of those who are going to take advantage of those who don't understand what's going on. You're going to charge your brother. Yet it may not be amiss before we enter upon the several modes whereby certainty is meant to be obtained in our courts of justice to inquire a little whether this uncertainty, so frequently complained of, consists and to what causes it owes its origins. So eventually, the main thing in this is we're going to figure out whereby certainty is meant to be obtained. Might have something to do with these records that I'm trying to get everybody to understand. People are apt to be angry at the want of simplicity of our laws. They mistake variety for confusion and complicated cases for contradictory. They bring us examples of arbitrary governments, and you'll find out arbitrary means they have very few laws, such as Denmark, Russia, Prussia. Wild and uncultivated nations, the savages of Africa and America, so on and so on, require the same fewness of laws, the same conscience of practice in a nation of free men, a polite and commercial people, and a populous extent of territory. And arbitrary, subject to individual will or judgment without restriction. That's where I want to live. In arbitrary, despotic government, where the lands are at the disposal of the prince, they're talking about you, and the land is your body, the rules of succession or mode of enjoyment must depend upon his will and pleasure, not your will that you write when you're dead, by your will as a man. Hence, there can be but few legal determinations relating to the property, the descent or the conveyance of real estate, and the same holds in stronger degree with regards to goods and chattel and the contracts relating thereto. So in an arbitrary, where subject to individual will or judgment without restriction, there's no question who gets what. You don't have to tell anybody. It's by your will. Under a tyrannical sway, trade must be continually in jeopardy, and of consequence can never be extensive. It is therefore puts an end to the necessity of infinite number of rules, which the English merchant daily reoccurs to and for adjusting commercial differences. So they're telling you this is the difference between law and equity or amity. One's meant to have a bunch of things wrong with it. Let's see if there's anything here we need to read. Marriages are there usually contracted with slaves, or at least women are treated as such. No laws can therefore expected to regulate the rights of dower, jointures, and marriage settlements. Few also are persons who can claim privilege of any laws. The bulk of those nations, the commonalty, boors, the peasants, being merely villeins and bondmen. So in their system, that's what you are. You're a person, and these are the things you get to be as a person. You get to be a villein or a bondman. And a bondman, that has to do with indenture, and there's a thing called indenture deeds, which we'll be talking about in another video. Those are therefore left to the private coercion of their lords. If you're a person, if somebody else is your lord, whatever they want to do to you, they can. We may see in these arbitrary states how large a field of legal contest is already rooted up and destroyed. So these arbitrary ones, they've gone through this before, and they tore that shit out. They've uprooted and destroyed, replaced some system of civil law in its legal contest with something else. Again, were we poor, naked people, as savages in America, strangers to science, commerce, arts, as well as convenience as of a luxury, the convenience is as of a luxury, so if we can convince you to do our work for you, then you will. We might perhaps be content, as some of them are said to be, to refer all disputes to the next man we meet on the road, and so put a short end to the controversy. Go to your brother first and settle the matter. For in a state of nature, there is no room for municipal laws, and the nearer a nation approaches this state, the fewer there will have occasion for. So the closer you can get back to the state of nature, instead of the United States of America, the less laws there are. When the people of Rome were a little better than sturdy shepherds and herdsmen, all their laws were contained in 10 or 12 books. But as luxury, politeness, and dominion increased, the civil law increased in the same proportion and swelled to that amazing bulk which it now occupies. He's talking back in the 17th century. How big is it now? The causes, therefore, of the municipality of the English law are the extent of the country which they govern, the commerce and refinement of its inhabitants, but above all, the liberty or property of the subject. Yeah, how much liberty and property are they going to give their subject? If you're a subject to English law, they're going to decide how much you get by statute. It's the same in America. It's the same anywhere civil law is in place. These will naturally produce an infinite fund of disputes, which must be terminated in a judicial way. Well, imagine that. They're going to poke at you with a stick and make you go to court and then take your stuff. So, you can either keep doing that with them or see if there's a better way. Because they said earlier in this that there's a way to get certainty in a case. But though in many countries everything is left in the breast of the judge to determine, yet with us he is only to declare and pronounce, not to make or new model the law. The judge is not there to make new law, he's there to declare and pronounce. So if you're the tribunal and a judge is a judicial magistrate, and in law the judicial magistrate's merely there to administer the orders of the tribunal, you make the law and have him declare it and pronounce judgment. So let it be written, so let it be done. But wherever this happens to be the case in any material points, the legislature is ready and from time to time may both, and frequently does, intervene to remove the doubt, and upon due deliberation determines by declaratory statute how the law should be handled in the future. Well, the U.S. Constitution says full faith and credit given to all public records, acts, judicial proceedings, forming the highest level of evidence there is, full proof of public record. I think it says in the Magna Carta also, the full faith and credit says that. Whatever instances, therefore, of contradiction or uncertainty may have been gleaned from our records or reports must be imputed to the defects of human laws in general and are not owing to any particular ill construction of the English system. Indeed, the reverse is most strictly true. And the reason for that is the English system is based on common law, and common law is merely the unwritten law of reason. Whatever is reasonable to a man is the law. So when you go on it as the man and are reasonable, it's the law. I don't know how much more strict you can make it on them. The English law is less embarrassed with inconsistent resolutions, doubtful questions, than any other system of the same extent and same duration. Just a second. I'll take this phone call. Okay, we're back. Sorry about that. I'm going to see how this works. I've never had to stop one in the middle. I hope I'm where I left off. Anyways, in this particular thing, the main thing I want you to see is the red. The same may be said of canon law, though the text, therefore, is not half the antiquity of canon law of England. Common law of England. So first in line, first in time means common law of England has more power than canon law of the Vatican. And all civil law comes from canon law, which makes it inferior to common law. It didn't say English common law. It says the common law of England. And Blackstone's defines common law as the unwritten law of reason, period. It's the unwritten law of reason. What's reasonable between two men? That's the law. And only a man can bring a claim against a man. A person cannot. They don't have the status. Man was created in God's image, not person. Where therefore a body law is so high antiquity as English is in general so clear and perceptuous, it argues deep wisdom and foresight in such and laid the foundations and great care and circumspection in such as have been built the superstructure. So basically, he's talking about the maxims of law, right? The maxims of law were written down, but they were known well before they were written down, and they covered everything about how men treated each other, not just in commerce, but just as neighbors, as each other. And those are the maxims of law, and they cover many, many projects. They are the law. You can always go back to the maxims. Or you just go to common law and invoke common law, the law of reason. And that's what we're doing. But is not, it will be asked, the multitude of lawsuits which we daily see and experience. Now, this is 1700s, man. He's talking about it back then. An argument against the clearness and certainty of the law itself. You would think so. What's the law? We have all these lawsuits all the time. By no means, for among the variety of disputes and controversies which are daily to be met with in the course of legal proceedings, it is obvious to observe how very few arise from obscurity in the rules or maxims of law. And a rule we get to use is that the public record, act judicial proceeding, has full faith and credit. So, they never break the law. It's just that the law is never invoked. An action shall seldom be heard to determine the question of inheritance unless the fact of descent be controverted. But this dubious points, which are usually agitated in our courts, arise chiefly from the difficulty there is of asserting the intentions of the individuals and their solemn disposition of property, in their contracts, conveyances, testaments. It is an object indeed of the utmost importance in a free and commercial country to lay as few restraints as possible upon the transfer of possessions from hand to hand, or their various designations marked out by the prudence, convenience, and necessities, or even by the caprice of their owners. Yet to investigate the intention of the owner is frequently a matter of difficulty among heaps of entangled conveyances or wills of the various obscurity. The law, rarely hesitates in declaring its own meaning, but the judges are frequently puzzled to find out the meaning of others. Thus the powers, the interests, the privileges, the properties of the tenant for life and the tenant entail are clearly distinguished and precisely settled by law. But what words in a will shall constitute this or that estate has occasionally been disputed for more than 2 centuries past. He's in the 17th century. He's going back to the 15th. More. He's going back to when the shit started around the 13th century. And will continue to be disputed as long as the carelessness, the ignorance, or singularity of testers shall continue to clothe their intentions in dark or newfangled expressions. So if you're writing wills, you're getting yourself in trouble. You're causing a problem based on this. So we've got to find out how we're going to rectify this. But notwithstanding so vast an ascension of legal controversies arising from so fertile a fund of the ignorance and willfulness of individuals, These will bear no comparison in point or number to those which are founded upon the dishonesty and disingenuity of the parties. Well, guess what? You think somebody's taking advantage of you? Well, he's telling you they are. Not that we don't know it. It's here in the law book. He's telling you what they're doing to you. So maybe he has an answer. Let's see what the man has to say. By either they're suggesting complaints that are false in fact, and thereupon bring groundless action, or by their denying such facts are true, and setting up unwarrantable defenses. Oh, so they're going to deny facts are true. Ex facto retior juris. The law arises from fact. If therefore the fact be perverted or misrepresented, the law which arise from thence will be unavoidably be unjust or impartial. In other words, if the right facts aren't being judged, the verdict could be incorrect for the situation. So, and in order to prevent this, it is necessary to set right the fact and establish the truth contended for by appealing to some mode of probation or trial which the law of the country has ordained for criterion of truth and falsehood. So truth comes from fact. In order to prevent this, it is necessary to set right the fact. When you set right the fact, the laws of the country has to ordain the criterion of truth and falsehood. These modes of probation or trial form in every civilized country the great object of judicial decisions. And experience will abundantly show that above 100 of our lawsuits arise from disputed facts, for one where the law is doubted of. So because the facts aren't known, they're disputed. If the facts were known, there would be no dispute. Now this isn't in this part of Blackstone's, but it said the word probation, and we're going to change tunes just for a second so we can see what probating means. This is about deeds again, how a deed is proven. It is lawful in many of the states and customary in some of them, as will be further seen below, to prove deeds instead of acknowledging them. That is, one or more subscribing witnesses goes before an officer authorized to administer oaths and makes oath that the grantor executed and acknowledged the instrument in the presence of the affiant and the other witnesses. So, 3 witnesses went, one came back and said all of them went. Well, where's the other 2? Or there were 2 witnesses and one came back and said they both went. Only one took an oath to be in there. To be a witness, you have to have an oath administered. You have to be deposed. And so one of them did, said the other ones went, and the officer makes a certificate of this oath on the deed, much as a certificate of acknowledgement is made. And the deed is then, and this certificate are both recorded. In some states, this is termed probating the deed. This is what's happened to not only your real estate, in my opinion, but also your body. In real estate, the deed is the land patent way back, and you can have a certificate that says you're the owner per the land patent. They're both recorded. With your body, your land is recorded also with an initial registration at your birth. And sometime later, some certificates of birth are produced. And these certificates of live birth, according to the Torrent system, says that there's 2. There's the outstanding copy and the owner's copy. And it sounds like as the owner, you're supposed to go accept the certificate and take it back so that you show that you appeared. Very similar to what we're trying to do with the warranty deed. I don't have this quite clear in my head yet, but that's what I'm working to as far as the body and claiming it as your land and being lawful owner of the landed estate known as your all capital letter name. So from now on, when I write something, I'm already telling them it is, and I'm making a public record that can't be rebutted. All right, so now we're back to Blackstone's. He just talked about, basically he's talking about most of the shit that happens in court has to do with disputing the facts, not disputing the law. And experience will abundantly show that above 100 to 1 lawsuits arise from disputed facts. Well, we got to get rid of these disputed facts then. So trial then is examination of the matter of fact and issue, of which there are many different species according to the difference of the subject or thing to be tried, of all which we will take curious view in this and subsequent chapter. For the law of England so industriously endeavors to investigate truth at any rat, that it will not confine itself to one or to a few manners of trial. The truth can be established many different ways in many forms of trial, but varies in examination of facts according to the nature of the facts themselves. This being the one invariable principle pursued, that as well the best method of trial as the best evidence upon the trial which the nature of the case affords, and no other, shall be admitted in the English courts of justice. Best evidence, best trial. These species of trials in civil cases are 7. We have by the record, by inspection, by or examination or certificate, by witness, by wager or battle. You can still duel if you want to. By wager of law, and by the jury. There's the 7 ways they have trials in civil cases, which is under canon law. Statute law, amity law, maritime law. Take your pick. But let's look at the first one. First, then, of the trial by record. This is only used in one particular instance, and that is where a matter of record is pleaded in an action as a fine, a judgment, or the like, and the opposite party pleads basically that there's no record. Upon this, issue is tendered and joined in the following form. And this, he prays, may be inquired of by the record, and the other does the like. And whereupon parties pleading the record has a day given to him to bring it in, and proclamation is made in court for him to bring forth his record, or he shall be condemned. And on his failure, the antagonist shall have judgment to recover. So right now, when you go in to these courts under trial by record, which is happening on the side of the road with a copper, anytime somebody hands you a paper, the trial by record has started. And he who has the record wins. Because if you don't have the record, you lose. The trial, therefore, of this issue is merely by record. For, as Sir Edwin Coke observes, who wrote an even older version of common law, which also is a book of authority, a record of enrollment is a monument of so high a nature, and imports in itself such absolute verity, that if it be pleaded that there is no such record, it shall not receive any trial by witness, jury, or otherwise, but only by itself. Thus, titles of nobility, as whether earl or no earl, baron or no baron, shall be tried by king's writ or patent only. Or so, trials of nobility. Are you a king or not? Which is all by the matter of the record. Also, in case of an alien, whether alien, friend, or enemy, shall be tried by the league or treaty between his sovereign and ours. And what they're talking about here, the aliens are talking about would be the Muslims, right? If you're a Christian, your sovereign is the Creator, right? Through Jesus. Well, if you were Muslim, that isn't necessarily the case. So he's an alien, but it still depends on how you treat each other. And also whether a matter be held in ancient demesne, D-E-M-E-S-N-E, or not, shall be tried by record of doomsday in the king's exchequer. That's the book. The doomsday book is the one in the registered deeds office. Ancient, something old, which by age alone has acquired some force. It's acquired all the force. And that other word, the name given to the portion of lands of a manor, which the Lord retained in his own hands for his own use of himself and family. These lands were called terra domicilis, or demesne lands, because they were occupied by the Lord. So that's your land. And you have it through ancient, so the manor, which to me is the estate that's being passed down through your history, is based on this ancient demesne, and can only be tried by the record of the Doomsday Book. Well, that Doomsday Book is the one we need in the King's Exchequer, which is the Treasury. And we could go into Exchequer for quite a bit of time. Basically that's the treasurer. And guess what? He's a judicial officer, has a special court. Actually says that he has jurisdiction in natural law. I've never seen a court that said that before, but put in Exchequer and Wikipedia and take a look. So this is why we're trying to produce a public record, because it is the highest evidence, and the trial record is only used in one particular instance, and that is whether a matter record is pleaded in an action. Well, so if you're going down to do this record with your real estate, you've just created a public record. A record or enrollment is a monument of so high of nature and imports in itself such absolute verity that if it be pleaded that there is no such record, it shall not receive any trial by witness, jury, otherwise, but only by itself. If you say there's a record and they don't, and you show it to them, it's over. That's their law. They put their seal on your paperwork saying that you have a public record. And let's go use it. So I have another video out shortly with something else you might use it on, depending on your situation. Have a great day. Hey everyone, this is RobbbRyder. Today's Thursday. What is today? Thursday, the 20th of October, 2011. I've had a few conversations the last couple of days. In fact, one just this morning. Brother in Ohio calls me and says he got turned away at the recorder's office, said they could not record a certified copy of a deed, only an original. Oh no, what are we going to do? Well, let's go figure out what the hell an original is. So an original, this is from Bouvier's, it's an authentic instrument. If you need to read the rest, you can, but I know that what that means, an authentic instrument. Let's go see what that means. So authentic, the term signifies an original, which there is no doubt. All right, so which there? Which here? Which there? Oh, which there? That's the way. And that's the way it's on a Bouvier's. I don't know why they run it together. Obviously, that's a word. But there is no doubt. So what's doubt? An uncertainty which exists in relation to a fact. And, I've talked about facts before. This is all trial by record. So the facts are in dispute. How do we get rid of a dispute in a fact? Let's figure that out. So some rules, not always infallible, have been adopted in doubtful cases in order to arrive at the truth. In civil cases, the doubt ought to operate against him who, having it in his power to prove facts to remove the doubt, has neglected to do so. In case of fraud, where there is doubt, the presumption of innocence ought to remove it. So they're telling you right here, if you have the power to prove the fact and you don't, then it should be found against you. That's the way their courts work. And we have the power to prove it. No judge is presumed to have any doubt on a question of law. And he cannot, therefore, refuse to give judgment on that account. So we're back to law, common law. No judge is presumed to have any doubt on a question of law. Okay, so I posted this before on a video, and in writing, it's the trial by record. A public record is the highest form of evidence. It's full proof, meaning there's no doubt. And how do we take a certified copy how do we turn a certified copy into a public record? Most of you have already done this. It's why we are going to the oath holder of the officer that witnessed your instrument. They did a certificate. It's a certified copy. Certificate, certified, it's all the same. It's just somebody's witnessed this piece of paper to say that it says what it says. That certified copy of the deed says that you're the grantee on it, right? All we need to do is make sure the person that put their seal on to say it was a certified copy has an oath. So how are we going to make it foolproof? You have the seal now on it, making it certified. So you went in there, they gave you a copy, they stamped it, and the girl signed it. Whatever that was today, that is the one you need to go have authenticated, or certificate of authority, or whatever it is. And this will be at the county, because this is a county officer that did this. So you're going to find out where the oaths are certified in the county. It could be in that office, or it'll be the clerk, county clerk, or it could be the clerk of the court of record. And they could all be the same person. It's amazing how this stuff works. Okay. You got the seal. It's authenticated. Just like the notary boss. The exact same thing you did on your acknowledgement certificate. And again, out of Bouvier's authentication. An attestation made by proper officer, by which he certifies that a record is in due form of law, and that the person who certified it is the officer appointed by law to do so. So the proper officer is the oath holder, witnessing that the person that certified the document, the person that put the seal on for you, be it the notary, or in this case it would be somebody out of the Register of Deeds office who put a seal on and said that this is a certified copy of a record. And all you're going to do is make sure they can do it, which means they have an oath on file. It's no longer a certified copy. It's, again, a public record, the exact same as your authentication is. So take your certified copy of the deed to the oath holder's office and tell them you need to have the person that gave you this certified copy of deed has an oath on file to do so. They give you a certificate of authority, and bingo, it's a public record. And it's really that easy. So this one's short and sweet. I just wanted to get that out so people can have seen it or see it after the show with Angela today. So we can cover some stuff that, not the same stuff all the time. We need to move this down the road. Okay, thanks a lot. See ya.